everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. In this episode, we're talking about a theme that's very close to my heart because I see it come up a lot. The question of relocating abroad post-divorce with your children. So with a lot of my clients being expats, sometimes having followed their spouse abroad for their job, they suddenly realize upon divorcing that actually they don't really need to be in that country anymore. And the natural reflex is to want to go back. But what happens when you have children and you want to take them with you? It's a very binary type of situation and often a very difficult one to agree upon with your ex. So today we're talking about the legal elements of this and how you can legally relocate your children when you have a disagreement with your ex who does not want you to move them abroad. So to talk about this topic, I invited Sarah Penfold. Sarah is a family solicitor at Paul Robinson in London, but she graduated in Australia from law school, and she has practiced exclusively in family law since she moved in Australia and since she moved to the UK. Sarah's got extensive experience in all areas, including divorce, financial matters, children, of course, and domestic violence. Sarah, thank you so much for joining us today.
Thanks, Chloe. Thanks for having me.
So this is a really difficult topic because it is a very binary type of decision, and there's a natural reflex for the parent who's staying in the country to resist their children being moved abroad. Could you tell us at a high level, if it's possible to do it at a high level, what the law says in England and Wales with regards to being able to move the children against the consent of the other parent?
Yeah, of course. You're right in what you say. It is kind of a bit black and white, isn't it? The court's either going to order that not you, but the children either can or they can't. There's no kind of in between, and that's what makes it so tough, so emotional, such a difficult kind of case and circumstance to come across. What the law says is that, essentially children, of course, have the right to a relationship with both of their parents, provided that it's going to be in their best interest to do so. And so in terms of relocation, it goes without saying that's going to hinder on a child's relationship with one of their parents. And the law says that it can be done, but it has to be, like I was saying, in the best interests of the children, pursuant to what is referred to as the welfare checklist. It's a section of the Children Act that sets out a myriad of different factors that help the court in deciding whether something, be it a relocation or a more kind of straightforward matter concerning children, is in those children's best interests. And so, yeah, to answer the question, yes, it's possible, but there is the onus is, of course, on the applicant, on the travelling parent, to bring that evidence to satisfy the court as to why the children should be able to move. And the biggest concern in the court's eyes is, well, what happens to that child's relationship with the parent who's staying behind, and is that going to be maintained? So that's kind of one of the biggest things that the court is I guess, wanting to know about in these kinds of cases.
Yeah, and it makes sense, and I'm sure it's the biggest concern for the parent who's fighting the relocation as well, is that how strong that bond can remain if they don't see their children as often. And so what kind of elements, if you can give us a flavor from the welfare checklist, what kind of elements would a judge be looking for to feel that actually the relocation is in the children's best interest?
Yeah, of course. Something that I think has kind of become quite topical in the maybe past couple of years is the wishes and feelings of the child. And the family court kind of holds the view that the older children get, the more, I suppose, weight is given to their views and wishes. And, it's rare, but children can get up in a witness box and give evidence. But typically, these wishes and feelings and thoughts and things would come by what is known as a Section 7 report. So a family report, I guess, the children and the parents meeting with a social worker, and that social worker speaking to the children and asking them how they feel about this proposed relocation. That social worker will then ultimately put that conversation into a report provided to the court to assist them. And if there's, something in there, a golden goose, such as, the child age 14, 15, because like I was saying, the older they are, the more weight their opinions are given. I'd be really happy to move, or on the contrary, I really don't want to move. I'm really worried how it's going to look with, maintaining my relationship with my dad or my mum. Those things are given a lot of weight. The court also, I guess, looks favourably at the applicant, so the travelling parent, having put significant thought into what they propose it would look like. Have they inquired with schools? Have they, looked at rental properties or properties to purchase? Where will the children be living? Have they given consideration to, I guess, the specifics of how that contact with the parent who's staying behind is going to be facilitated? I think it's all well and good to say, in a witness statement, yes, I'll continue to facilitate that contact, but okay, how? It's not as simple as when parents are living 10 minutes from each other. We'll see you on Saturday mornings and Wednesday overnight. It's either, isn't it going to be weekends or school holidays or the half terms, etc. It's not as simple as, like I was saying, just being down the road. Telephone contact, video calls. I think, the kind of the practical reality being considered and being thought out and evidence being put to the court in that regard. Have they made inquiries with schools, emails to confirm that there's spots available, and that they've spoken with estate agents about rentals or buying a house, for example, like I was saying before. And also, I think something that is relevant and something the court turns their mind to is, does this applicant, this travelling parent, actually have a genuine need or desire to move, or are they kind of doing it out of spite and with the wrong kind of intention, i.e. to harm or limit the children's relationship with that parent, of course, subsequent to a divorce. These are, I guess it's so huge, isn't it? It's a huge issue. So I guess that's just a small kind of handful of what the court would look at, what they take into account.
It makes total sense, but I guess in a lot of cases, the relocation is actually primarily for the parents' benefit, because they want to move back home or because they have a job opportunity. Does that get taken into consideration, or is it only the children's aspect that's looked at?
Yeah, of course. I mean, I think it's relevant, but the overarching kind of principle is what I was saying before, the best interests of the children. So, I mean, yes, of course, it's of relevance, isn't it? Like the example you just gave, Chloe, about having been offered a job, that of course infers stability on that parent, financial support, ability to then provide for that child, etc. But it's a lot bigger than that. Yes, of course, there's this stable job, the child will be provided for, but there's all of those other things to turn their mind to. Is there a school there that's sufficient to meet this child's educational needs? And how are they going to maintain their relationships with not only the other parent, but family in their, the previous country as well? So to answer the question, yes, I think it's a relevant factor, but it's quite a lot bigger than that. Yeah.
Yeah, it is. And do the courts have a bias towards status quo and a preference for stability, and therefore it's only by exception that they would truly consider the relocation applicable, or do they really look at both scenarios equally?
Yeah, it's so hard to say because I think, I can imagine that every application for a relocation put before the court is so different. I think, I can't really say whether they lean towards kind of one case or another. I think what's important is setting out all of those practical, I guess, issues that are going to crop up, ensuring that the child's, I guess, needs are met in terms of, education, housing. That is something that's been thought through. Maintaining contact with that other parent. So I do. I think, it's such a subjective discretionary court. Every case is different, every scenario is different, and every child's different. It is. It's tough to say whether they lean one way or the other because I think it does. It really just depends.
It depends on the case. And do they take into account how far the relocation is? So, if you're moving to France, it won't be the same as if you're moving all the way to Japan. Is that a factor?
Of course. Well, I think it comes down to, and how it would be relevant is the frequency of that contact because, of course, arguably, France or Germany, the Netherlands, for example, it's realistically, an hour or two from London versus, like you were saying, Japan or literally the other side of the world. Children could, potentially sort of get on a flight after school on a Friday afternoon, be with the other parent back in the UK for, 7 p.m. and then back on a Sunday evening. But if you've got like a 20 or 15 or longer hour flight to look at, then that's not as possible, which again makes it harder to then facilitate, how I was saying, the regular contact. And so, it's relevant. Absolutely.
Yeah. And so you mentioned earlier, actually, the preparation from the parent who's making the petition to move, in showing that, first of all, they've got everything lined up so that they can, easily slide into their new life.
Yeah.
But also demonstrating that they have plans to keep the other parent part of the children's daily life.
Yeah.
And I actually have a long distance parenting plan that I use as a template with clients to help them pull that proposal together. And actually, in most cases, they negotiate that rather than take it to the courts. But it's really making sure that you've thought through every implication of that move and how it's going to work in practice. What kind of evidence does the court request in that respect, beyond the school enrollments and accommodation?
Yeah, I think what you were saying about a parenting plan, I think that's a great kind of point of reference to, for an applicant, for a parent looking to move, to think about what it is that they should be considering. So, like you were saying, contact with the other parent. Yes, schooling. And like I said before, evidence of potential spots in schools and rentals and things like that. Conversations that they've had with the other party about how it would look in terms of contact. A commitment to honour their obligations pursuant to parental responsibility, i.e. joint decision making in relation to long-term decisions, which is of course a separate issue to just the living arrangements. So I think, I guess an understanding that it is such a huge issue and it's not just something that can be done overnight. It's not like you pick up your whole life, put it into a box, you move, you arrive, and that's it. Everything is all in hand. It's all sorted and it's all how it was. We're just in another country. I just think, an acknowledgement and an understanding of the seriousness of the significant impact of a move like that, and making sure that it's all kind of thought out sufficiently.
Yeah, that makes sense. But I would assume they would also look at the parent who's being left behind, how much contact they had regularly already with the child. If they were only seeing them a couple of days a month, then they probably have less ground to refuse the relocation.
Exactly. And this is what I was saying before about how there is kind of no, hard and fast, the court prefers X, Y, or Z, because it all is so different, because exactly what you say is right. If it's the case that, the non-traveling parent has seen the children an hour a month for the last 5 years, then of course that's going to go in that applicant's favour, isn't it? But if it's the case that, it's week on, week off, or every second weekend, for example, it's going to be a lot, not a lot harder, because again, it all depends, doesn't it? But it's all, that's like given more weight as to supporting the applicant's case than the former example that I just gave.
So in practical terms, so for somebody who's thinking about relocating and wants to start that process, what would be the steps? So before getting to court, what would be the initial steps they can take to try and find an agreement, and then how does it happen if they really can't agree?
Yeah, for sure. I think, exactly what you said. I'm a bit of a broken record when it comes to saying, there's so much that you can do before making an application to the court, because, of course, there are circumstances. And like I said right at the start, particularly like this one where it's black or white, you relocate or you don't. There comes a need for judges and for courts, and I understand that, but I think it's incredibly stressful, it's time consuming, it's costly. So I think if there's things you can do to avoid that, then you should absolutely take those opportunities. In terms of how you would go about that, I think examples include, a mediation, and be it on the party's own behalf with a third party mediator present, or with solicitors present. That can either be on a shuttle basis, so the parties are in separate rooms and a mediator kind of floats through and tries to facilitate discussions, or a round table sort of conference, having those open discussions all together, and seeing how that goes. Negotiations through a letter, through correspondence, and I've done this previously, just recently actually, literally putting an offer to the other party in writing. This is what we propose, and putting exactly in there how it would work in terms of contact, phone calls, school holidays, all of those specific things I was saying about before. Make sure that they're all listed in there, because what I said to this client and in this scenario was, imagine you as a parent just get this letter saying, oh, I want to move to, Japan, to use the same example, and that's kind of it. It's you'd be incredibly taken aback, and so
you're never going to respond positively.
Exactly. Exactly. And so I think to have as much detail in there to kind of reassure that parent that exactly what I was saying before about what the court wants to know is, that there's a genuine reason for that application, that relationship would still be facilitated. Instruct a solicitor to send a letter and see how that kind of goes. Another method is an arbitration. And so that is kind of a mock, I suppose, court hearing. So a high level kind of barrister with the relevant qualifications acts as judge effectively. They're known as the arbitrator, and they hear both parties' evidence, they hear from the barristers, and they make their decision on the basis of all of those things and the written evidence, the papers, and that decision is kind of just as binding as a court order would be. And I guess ultimately, if agreement is able to be reached by one of these methods, you would put it into either a parenting plan or a child arrangements order, which is an order of the court that is just as binding as if it was an order that was made after a trial and made by a judge. But yeah, I strongly believe, and I think a key to my practice is, just exhausting every avenue you can before taking things to court, because it's something to consider as well is, while you're in a mediation or you're sat around a table and you're having these discussions and trying to work things out between yourselves, it's all in your power, isn't it? And it's all in your control. You file an application, you go before the court. Yes, you put all of the relevant evidence before the court and they've got everything they need to make their decision, but it's taken out of your hands completely. And so it could be the order could be what it is you're asking the court for, or what the other party is, or it could be something else. So I think that's always something to keep in mind. But I cannot stress enough, so much can be done before making that application. But to answer the question, if that does become what ultimately is necessary, because like I said, of course there's a place for it, and things do get to a point where you've done all that you can and you've exhausted all avenues, and it's a matter that needs to be resolved. You need to get an answer. So sometimes, of course, you do have to join. You would do that by a C-100 form filed with the family court, and they would kind of triage the application. You would first be listed for what's known as a directions hearing, kind of a procedural hearing, orders for parties to gather the relevant evidence, so swear witness statements, and go off and have prepared a Section 7 report from a social worker, like I was saying about before. And then you would come back and you would have a second hearing, see how that goes, use all of the evidence and see whether any kind of agreement can be reached or interim, I guess, resolution can be made. Failing that, it would then be listed for the final hearing, which is where parties would be cross-examined, further witness statements would be prepared, and everything is kind of put to the court all at once over usually a few days. And then the court is given time to write their judgment, make their decision, and then that's it.
Yeah.
So sort of nutshell on the process. Yes.
It's quite, I would imagine, both costly and long to go through the court system for that.
Definitely, absolutely. I think it kind of seems to be getting longer every time I look, but I think if you were to file this C-100 that I was saying about tomorrow, I don't think you would expect a court date for 18 months at least, that final hearing date. Yeah, it is. It's just sort of the unfortunate reality of just the volume of applications there are before the family court. Yeah.
Another reason to try and speak to each other directly and not go through the court system.
Exactly right. Exactly.
And so, a lot of what you were saying, and it's true, is, it is, essentially a binary decision. You're not going to have the child live somewhere in the middle between their two parents. Yeah. But there are a lot of things you can put in place to kind of round the edges, right? Make it a little bit more palatable to the parent who's seeing their children move abroad. And that's the purpose of the parenting plan that I work with, is to try and show that even though the children are going to move somewhere else, there's still going to be that ongoing contact, there's still going to be that regular involvement. But when you delegate to the court to make that decision, or to an arbitrator for that matter, will they only make the decision as to yes or no, whether the kids can move? Will they also define the terms of that move and how that contact will be facilitated, who will pay for flights, etc.?
They can do, yeah. So it won't literally just be, a one-page thing. Or the children, Joe and Jen, are permitted to move. It would go into incredible detail about all of those things you just said. The contact with the non-resident parent, how that would work. Is the not the non-resident, the non-traveling parent.
Yeah.
Well, which would be the non-resident parent. How that would work. And so, would the non-traveling parent fly to where the children are, collect them at the airport and fly back with them? Or would the children fly unaccompanied and the other parent pick them up? Who meets those costs? How does it work on special occasions? Easter, Christmas, birthdays, Mother's Day, Father's Day. There's so much to take into consideration. And so, the final order made by the court would be able to deal with all of those things. Yeah.
Okay. It's not that there's just that decision, and then you still have to go back to the negotiation table and discuss the implications of that decision. So at least you get that resolved.
Exactly. Yeah.
So Sarah, what would be your 3 tips, kind of as a summary, I guess, of everything you've said, to someone who wants to relocate abroad with their children? What would you recommend they think of and keep in mind?
My 3 tips. I think ensure that you are able to satisfy the court that there is, like I was saying, a genuine need for the application, be it, like you were saying, a job opportunity or some sort of education opportunity for the children that wouldn't be available where they are currently living, versus just kind of, like I was saying, doing it subsequent to the divorce in light of all of those feelings that person may be feeling and wanting to limit or restrict the relationship that the children have with that other parent. I think ensuring that you give proper consideration to the practical reality of what that move might look like in terms of living, school, and education arrangements, relationship that the non-traveling parent would have with the children and how that would be facilitated. And tip number 3, look, I think probably take legal advice on that issue before you go ahead with lodging a C-100 application on your own behalf, just to make sure that if it is something that you're going to do and follow through with and see through all the way to a trial, to a final hearing, that it's something that has a basis, and just to, I think, have a better understanding of these things that I've stepped through, the things that the court would want to know about, just so that this potential applicant kind of has an idea of what to expect, court time frame, associated costs, and how the court views it, what they view as important. I think just taking advice and having a better idea of what exactly to expect. Yeah, no, that makes a lot of sense. Well, thank you so much, Sarah. I had one last question before we wrap up, and this is probably a bit of a finger in the air kind of answer you're going to give me, but do you find that the majority of cases for international relocations get rejected? A lot of them get accepted, or is it really a 50-50 conversation at the very beginning? Yeah, it just really does depend. I know that's such a wish-washy answer, but it really, really does. It depends on the evidence that's there. It depends on the judge that is sitting and deciding that particular case on that particular day. The strength of the evidence, the age of the children, the surrounding circumstances, the relationship with both of the parents. There's just so many moving parts that it really does just depend. I hope that answers the question. It's good to know that it's not there's no bias in one way or another when you're starting off the process. No, exactly. It's not rigged from the start. Well, thank you so much, Sarah. It's such an interesting conversation and so much to discuss, really. But I think where we keep coming back to is that it depends so much on the case, but keeping in mind that always paramount consideration is going to be what's best for the children. And that's really the case that needs to be made, whether you're negotiating or going to court. No, definitely. Absolutely. Thanks so much, Chloe, for having me. It's been great. I hope that's all been helpful and useful and interesting. I'm sure it will be very helpful to people who are facing this situation. Help them to make the right decisions and to really think through all the implications as well. Good. Perfect. Thanks, Sarah. Thank you so much. Soon.